Let's tell people at home what the EB-5 visa is and how does it work. What are the first steps? How do we start this application process? What are the most common challenges and risks that people take to get into the EB-5?
Are you thinking of working or investing in real estate in the United States? This episode on the EB-5 visa for real estate investors is just what you're looking for. We're going to explore the EB-5 eligibility requirements, factors to consider when evaluating a real estate investment, common challenges EB-5 applicants face, how the EB-5 visa leads to a green card, and much more. Joining me to cover this exciting topic is Carolyn Lee, an immigration professional with extensive experience in all aspects of the EB-5 visa. Carolyn has helped international entrepreneurs invest billions of dollars under the EB-5 program, and I can't imagine a better expert to walk us through the topic today. Let's get started.
So, Carolyn, like I mentioned, we're going to be talking about the EB-5, and before we even move forward, let's tell people at home what the EB-5 visa is and how does it work.
That's a great place to start. So the EB-5 visa is a path to permanent residency. Okay, it's a green card path. And it is premised on investment in a U.S. enterprise, U.S. business, that will create at least 10 full-time jobs for U.S. workers. And the investment has to be made by the individual investor from lawful sources only. And that's, yeah.
Sorry, so when you were saying about the investment, right? It's an individual. It's not a company. It's just the individual putting the money, right?
Exactly right. Yes.
And what are the benefits of the EB-5 together with all of the how it works and all? Like, I'm sure it includes some benefits, and that's the reason why a lot of people is choosing to go that way. If you could also add into there the benefits.
Sure. So the benefits at the end of the day is U.S. permanent residency. So this is the golden ring that attracts investors to this program, to the EB-5 program. And thanks to the recent changes brought by the EB-5 Reform and Integrity Act of 2022, there are incredible interim benefits as well, meaning benefits that the investor can avail him or herself of even before becoming a U.S. permanent resident or green card holder. And one of these benefits is concurrent adjustment of status filing. And what that means is that the green card application itself can be filed concurrently or at the same time as the EB-5 classification petition is filed. And the filing of the green card application, also called adjustment of status application, allows the investor and family members, including spouses, to apply for work and travel authorization at the same time. So it's getting
a pretty flexible one, right?
It is universal work authorization. It couldn't be more flexible. So this is a tremendous benefit to EB-5 investors that was brought by the RIA, the RIA, EB-5 Reform and Integrity Act, which has really, increased the level of interest in the program, even from, it had been enjoying tremendous popularity from about 2015 on, really going back. The 2015-16 were really the height of its usage by investors. But it's brought in a whole other class of interested investors. Students, for example, F1 students in the U.S., for them to live and work in the U.S. after their degree, for the most part, the traditional pathway is through the H-1B visa. And there's full of uncertainty there because you've got to find an H-1B petitioning employer who's got to petition you for the H-1B. And then you have to be one of the lucky winners in the H-1B lottery to even have a toehold into this pathway of being able to work and stay in the U.S. So the EB-5 concurrent adjustment of status and the work and travel authorization that it brings has, allowed the student investors in this example to kind of have both. You can certainly pursue the H-1B path, but also have this more assured path to work and travel.
And it's definitely more, I mean, it sounds way more attractive as well. I mean, the benefits are really sweet in this case. Now, you were talking about direct investment, right? And this is one of the big parts of the EB-5. What are the main requirements for this? I mean, not just for the EB-5, but especially when it's related to direct investment.
Right. And we're seeing this exciting increased interest in the direct EB-5 investment as well, which, the EB-5 Reform and Integrity Act didn't directly, address and revolutionize. It certainly did that with the regional center-based investments and projects, but not so much with and yet there's a heightened interest in the direct program. And so to your question, the key difference between the direct EB-5 investment and the more popular regional center-based EB-5 investment is that in the direct or standalone context, the investor profile is generally different. They're much more engaged. They're usually investing in their own U.S. businesses that they are operating, that they're putting up and building, either by themselves or with other close partners. Number one. And number two, the job creation rules are very different, are entirely different. Yes, in both scenarios, the investor's investment has to create 10 full-time jobs for U.S. workers. But in the direct or standalone context, the 10 U.S. workers must actually be live, real people backed up by I-9s, W-2s, payroll records. And in the regional center side of things, the job creation is proven up very, very differently.
And going back a little bit to the investment part of it, right? So the minimum investment required for this is, first of all, how much is it? And also, it really depends on the location of the real estate projects people want to start, or how does it work?
Yes, great question. So the minimum EB-5 investment is 800,000 US, and the base EB-5 investment level is 1.05 million. And to your question, what determines whether you're at the 800,000 level or the 1.05 million level? It does depend on the location of the enterprise and whether the location of that real estate project or the enterprise is in a targeted employment area. And a targeted employment area is an area that's defined as high unemployment or rural. Now, in the regional center side of the equation, there's also one other category that's not dependent on location. It's dependent on the project type, which is infrastructure. And so for projects that meet any of those three criteria, being located in the high unemployment, being located in the rural area, or being an infrastructure project, those all qualify at the lower investment threshold of 800,000. And on the direct side, high unemployment area and rural.
Got it. Now that we have a better idea of, like, all right, well, this is how it works, the benefits, the money required. What are the first steps? How do we start this application process?
Yeah. So there is a preparatory process that's important because this is about documentation and proving your case, proving that you meet the eligibility requirements for EB-5 classification. And also, if you're concurrently filing, that you meet the adjustment of status eligibility requirements as well. So let's spend a little bit of time on the EB-5 classification requirements. So like I mentioned earlier, we've got to establish that the investor is bringing lawful source of funds to this EB-5 investment. So let's assume it's 800,000 because that's where most investors are, whether they're in the direct or regional center camp. They're investing in a TEA and it's at the 800,000 level. And so the investor has to show, okay, so I'm making this investment of 800,000. And in the case of the regional center, also the administrative fee. And I'm going to show you, USCIS, exactly where I got this capital so that you can be assured, you can have comfort that the source of these funds is entirely lawful. And we have the burden of proof on that. We've got to prove up to the examiner's satisfaction that these funds are lawful.
And
yeah.
no, sorry. Go ahead.
I could just go on. So you'll have to stop me. You'll have to get
no,
in there and just
good.
be like, whoa.
Yeah. So, I was going to jump already into something else, but I want you to finish that idea because there's some more in there.
Okay. Well, and so, the source of funds, it's going to vary because this is where the investor's story really shines. This is about the investor. Where did this investor get this capital? If it is a student, it's usually a gift from parents. And so, the student is in the United States and pursuing a course of study. And it's usually something really fun, and fabulous, like pharmacology or physics or anything, law, business. It's always wonderful to see that. And then, it's usually their parents, they've worked hard, developed, usually outstanding careers in their field, and they're undertaking these transactions. They've accumulated this income and they've bought an asset, like maybe it's a house or, some sort of real estate property, and they've sold the house or they've mortgaged the property. And they're using the proceeds and gifting it to their beloved child, so that the child can realize his or her American dream of being in the U.S., living in the U.S., starting their own careers. And so, that's the story that the source of funds, or part of that, kind of really moving story that the source of funds is telling.
Lucky them, by the way.
Yeah, well, we all have our gifts and things that we're blessed with and grateful for.
Now, I do have the obvious question that coming next is, how long does it take? How long this process takes?
Yes. Well, it is a multi-year process, and that is not going to change. And there are 3 steps in the process as well. The first 2 can be taken together with a concurrent filing if the investor is in the U.S. and meets the eligibility requirements for adjustment. And then there's a 3rd step, which I don't think we've touched on yet, which is the petition to remove conditions on the U.S. residency. So the U.S. residency that the EB-5 investor and their family members get is a conditional permanent residency. Yes. So it's conditional because it's initially valid only for 2 years. And toward the end of that 2-year period, the investor has to make this 3rd filing and show that, I deserve to have these conditions lifted because I've kept my investment in and I've created the jobs. Those are my conditions and I've met those conditions. And so please lift the conditions. And the timeframes vary. I mean, I'll say that it's a multi-year process. That's true. And then, but beyond that, it can be anywhere from, let's say 1 to 2 years for step 1, another year for step 2, and then 2 years of conditional residency. And then you file your petition to remove conditions. So that's really a minimum of 4. Minimum.
4 years.
Minimum of around. Yeah. And then it could be much longer. Because it depends on factors beyond our human control. What are they? USCIS processing times. Other applicants ahead of us in line. We not only have no control over those things, but we have no visibility either. And so for that all important question that we get all the time, which is completely, of course you're going to want to know before you undertake this journey of multiple years of this tremendous investment. How long is this process going to be? How long are we going to be in this? Of course you need to know. And it's, a little embarrassing. I mean, it's more than a little embarrassing, but we can't tell them. We cannot tell them with any reliable certitude how long this process is going to take.
Now, I mean, still, I still feel that some of the benefits are actually balance the weight, so it makes it
It's
worth.
got to be. You can look at the numbers, look at all our clients, and it's
Exactly.
no question.
That's where I was going. It's like, I mean, it's the reason why it's popular, right? Obviously, as Journey, we are in the business of business plans, right? We create business plans for people who wants to get into any sort of visa. That's where we are. And obviously, if you are at home, want to know more, go and visit our page. But in adding a business plan to your application process, what do you think is very important for the EB-5 that is like a must-have?
Oh, yes. I have a lot to say on this. And coming from the days, Marcos, going back to early 2000s, right? When I first started doing this, writing them from scratch, which now, thankfully, we don't have to do because of wonderful providers in this space like Journey. The most important thing, really, is that it has got to be compelling. It has got to make sense. It's just got to hold, beyond the elements, because there are specific elements, as you know so well. They're the matter of whole elements, right? It's got to have market study. It's got to have feasibility. It's got to have, a SWOT analysis. It's got to have a description. It's got to have permits if they're applicable. It's got to have contracts. It's got to have all of these elements. But at the end of it, it's all got to tell a story that somebody reading this, most importantly, the examiner reading this, has got to be able to picture this. What is this business? What are they going to do? How is it positioned for success, defined by the 10 required jobs at the end of the day? And so I think this is the part, that's the difference, I think, between an excellent business plan and one that checks the boxes.
Is that, I think, especially the part where you mentioned, is that you tell the story, because a lot of the people reviewing this, they're not business experts. So you need to make sure it's super, super clear. So that's absolutely right. Now, moving a little bit into the back to the EB-5 itself, right? Mm-hmm. What are the most common types of investment that you see in the EB-5? Because there are many, right? And we reviewed a few of them in the past, but what are the most common types that you've seen?
Well, I mean, generally, the most common is going to involve some form of real estate development. And now the operating business itself, it could be anything, right? Truly. And that is one of the things that I enjoy the most about this is it's really open, very open to whatever kind of business that one can imagine. And you've got to build it. And so there is a construction and real estate component in most.
And when I want to go back a little bit to the TEA. Can we dig in a little bit more, because maybe it's a better chance for someone who's thinking, well, I'm not going to go this way because this one is more attractive, and maybe you have better chances to get approved because you're developing employment and this TEA, right? So can you explain us a little bit more about the TEA?
Sure. So the function of the TEA and the downward adjustment in the investment amount is to incentivize investment in these types of projects, right? That's the purpose of the TEA and the infrastructure category, is to incentivize investments into these policy priority areas and project types. And so, but to your question, if you're asking, well, just because my investment is in a TEA, does that enhance my the likelihood of it being approved? The answer is no. Because the TEA addresses the investment amount, and you have to prove that you're eligible for that downward investment amount. You've got to prove that you are actually located in TEA or you're an infrastructure project. But you've also got to establish all of the other eligibility criteria, under the umbrellas of investment and job creation. And so, just because you're in a TEA, it doesn't sort of diminish or absolve in any way the requirement to satisfy those other elements also. That said, the EB-5 Reform and Integrity Act, RIA, did elevate the rural projects in rural areas. And it did so in two very important ways. First, it's got the lion's share of the set-asides. And we didn't talk about the set-asides in the visa structure of the classifications and the numbers. But it's all about numbers because we have a limited number of visas that are allocated to EB-5 and all the other preference categories. And in our case, the base is about 10,000. It's a little under 10,000. And the new law, RIA, carved out or set aside 32% of the annual limit to investments in the TEAs and infrastructure. And of the 32%, 20% is taken by rural and 10% high unemployment and 2% infrastructure. So, we can see right away that rural is advantaged because it's got 20% of the 32, right? So that's one advantage. And the second advantage is that the statute, the RIA, specifically calls out rural petitions for prioritized processing. And it isn't immediately obvious what that means, but it is suggestive of faster processing, coming to our earlier discussion of speed and timing. And that is our observation as well. We don't have formal regulations or anything specific about what it really means and how this affects processing at USCIS. But it is our observation, shared by others, that rural petitions are being processed faster.
Is it too soon to know because the law changed recently, or?
Well, it isn't in that there have been approvals since 2022. So 2022 is when the new law passed, March 15th. And so cases started to be filed in 2022, and here we are at the end of 2024. And so we are seeing across the board better processing. I mean, again, it's not across the board across all the cases, and there's tremendous variance, I must say. But I mean, when I step back and think about the fact that we have post-RIA investors who have been approved for conditional permanent residency, they are in their conditional permanent residency period right now. That's really amazing.
That's fast.
Yes. And of course, we don't know, it's not across the board, and we don't know how long that's going to last. And, it's very dynamic, right? Because it's, as there are more investors and, as USCIS capacity fluctuates, and then other sort of macro things like, the numbers move in some other category, that affects the whole system. But yeah, that's what keeps us on our toes.
Yeah, that is very interesting. Now, I'm going to when you mentioned about real estate development being one of the most popular ways to get into the EB-5. Do I have to do it on my own, or can I bring a co-investor? Like, can I do it with one other person, or maybe two other person, to get into this into the EB-5?
So, are we talking about the standalone, the direct model, or the regional center model?
Which way we want to, like? I would love to cover both, but which way you want to start?
We'll do both.
There we go.
So in the regional center model, it's almost always going to involve a pooled investment structure. So you're almost always going to be co-investing as an investor with other investors, with other LPs or members. who are investing in that new commercial enterprise. Now, in the direct or standalone model, under the RIA, there is no pooling or co-investing with another EB-5 investor. It's got to be solo.
Okay.
Now, there can be other investors and partners and co-owners of the business, of the new commercial enterprise. It could be your spouse or your family members or friends or business partners. But there can only be one EB-5 investor per new commercial enterprise. Now, this does not preclude structuring to allow for multiple investor participation in a larger project, but there'll be one investor, EB-5 investor per new commercial enterprise.
Got it. Now, thinking about the challenges, obviously, it's never as easy. There's a reason why sometimes it takes 4 years. There's a lot of things happening in between. What are the most common challenges and risks that people take to get into the EB-5?
Well, I mean, I think there are a number. And so I think one of the main things is project due diligence, on the regional center side. These are difficult to really understand. And there's a lot. And the drafting is, there, because of the inherent risks involved with pooling all of this capital and undertaking this venture, which by definition has risk. There's going to be protective language, right? Let's just pick the offering memorandum, the private placement memorandum, the whole purpose of which is to express to prospective investors the potential risks, because these are unregulated securities. They are securities, but they're not publicly traded. And so we're not Securities Counsel, but the point I'm making here is that all important disclosure document is, there's a lot there that investors have got to slog through, whether they do it themselves or, with the help of advisors. And that's just one very, very important document. And then there are others, there are the subscription documents. There's the business plan that we talked about. The business plan is a hefty undertaking. It's got to be, because it's got to have all of those matter of hoe elements that we talked about. And it's got to have all that backup evidence as well. And you've got to evaluate whether the case is made for being comprehensive. And then in the regional center context, you also have the economic impact study. You've got the job creation analysis. It's not a head count. It's a mathematical modeling study. And you've got to have competence to review that, know what it says, and know whether it is compliant or review for compliance with immigration requirements. Now, your everyday EB-5 investor is not going to have the skill set to do that. But somebody who does has got to review those documents for the investor at the outset. And even doing that doesn't eliminate all immigration risk, certainly doesn't do anything with respect to the commercial risk. And so, because it's difficult to predict USCIS interpretation, it can change over time, they can disagree with an aspect of eligibility. So it's a complex soup, and you need to have competence to get in there and begin to chip away at it and understand and evaluate whether or not the project meets EB-5 requirements, okay? So I'd say that's fundamental and very important.
Would you also say that these are some of the reasons why you get denials? Like, what are the most common reasons that they say no?
The common reasons that USCIS can say no can go to project eligibility. Mm-hmm. Now, I mean, I say can versus is. We don't have the numbers. We don't have the statistics on denial rates or denials by reason. which would be nice to have. It would be yet another data point that it would be wonderful to have. What didn't you like about this, right? We don't have that. But I can tell you, having done this for 20 years, I've seen them because we get called into counsel when there are gnarly project-related RFEs and NOIDs and other adverse situations respecting the project, including investigations. And so it is an important challenge that you want to try to approach it with professionalism and competence. And then on the other side, there's the investor-related issues, the source of funds, like we just talked about. Let's imagine where, that story is not told in a way that makes sense. And where there are also inconsistencies. Inconsistencies, I've got to say, is the bane of immigration journeys. Yeah, in regardless of the category. Because if there's inconsistency, it introduces doubt.
Exactly.
And
no trust.
And it is, and we are, and that is the job of the examiner, to be persuaded if the evidence is there, right? They've got to be looking at things with a skeptical eye, and to be proven that, no, you can put your skepticism to rest, right? But if there are things in the file that, rather than putting the skepticism to rest, raises other questions and doubts, that is problematic. And so, careful preparation do these facts hang together? Are they consistent with each other? Do they make sense? And are the key points supported? And if they're not supported, some explanation, the awareness that, okay, so you know what? This is the story. These are the key bits of evidence. But you know what? We're not quite there in this one node of the tale, and recognizing that and working around it and with it and building up other supporting evidence, addressing it head on, what have you. But appreciating what it is that will maximize the chances for a winning case, identifying where the potential flaws might be, and managing them.
That's a great piece of advice for the people looking at this. Obviously, for the people looking at this, especially on the real estate side, there's another avenue, which is the E2. So we have the EB-5, we have the E2. What's the key difference for those two?
Yeah, great question. We do a lot of both because we specialize in investment immigration. One of the differences is the investment threshold. Huge, right? Because with EB-5, it's a minimum of $800,000. With the E2, there is no minimum as a matter of law. And the legal test is the substantiality is based on the nature of the business, which makes sense. So if the nature of your business is, let's say, building widgets in upstate New York, that's a capital intensive business. We need machinery, we need land, we need building, we need people. And so substantiality threshold is going to be commensurate with that. It's not going to be $75,000. On the other hand, what if I'm an IT developer, and all I really need is a machine and a desk? And that might be realistically, quite low. It might be 20,000. We, though, as a general matter, that's defensible, of course, under the substantiality test as written, but higher the better, because you want to establish to the consular officer or to the USCIS, this is a serious commitment. It's a substantial commitment of capital. And we are poised, once you issue that visa, to launch and be successful because we've committed the resources to do that. So the investment threshold is a big difference. I would say another thing that's worth mentioning, because it's interesting too, is, in the immigration space, I think we all assume everybody wants that golden ring. Everybody wants the green card. Well, not everybody actually does.
That's interesting.
especially if you're high net worth or ultra high net worth, because of lots of reasons that I'm not competent to address, including tax related reasons. And so for certain investors, they don't want to be U.S. permanent residents, but they want to have the ability to have presence in the U.S., to be here regularly, to undertake their business operations that are defined in the scope of the E2 application. And for them, the E2 makes more sense than the permanent residency route of EB-5.
And can you, if you apply for or you start the process with E2, can you switch into an EB-5?
Yes, you can. There are some pitfalls, I would say, to avoid, because while the framework is related across the two categories, there are actually very, very big differences, including the source of funds and the capital structure. An example is in the E2 context, and we see this with E2 clients, retained earnings constitute investment. It counts. If you have grown your business and you've kept your profits in the business, that can actually count toward your level of E2 investment. It does not count as capital in the EB-5 context. You've actually got to take the distribution, realize the earnings, and then recapitalize, put it back in for it to constitute capital as defined by EB-5. The other big difference is job creation. To the earlier question you asked, when does E2 make more sense than EB-5? Some businesses are fantastic businesses, but they're not the kind of business that needs people to succeed. And if that's that kind of business, it's not suitable for EB-5 because we've got to have job creation.
Exactly.
But even in scenarios like that, if the business evolves and grows to where, there are people, employees and positions that are needed to support further growth, then that can be, another occasion to talk about converting or changing to EB-5.
And Carolyn, when you were mentioning that there's been changes around, especially around the EB-5, what are the main changes or updates that people should be aware of?
So the investment threshold, which I'm glad we touched on for sure. Job creation, the basic 10 jobs, that has not changed. But the formula for the way in which it is calculated has changed. I should say formulas. So particularly in the regional center investment context, one wants to be aware of that as one reviews the economic impact analysis. The other changes I think we've mentioned, but worth highlighting again, is the numbers, the set-asides, the visa subcategories within EB-5 that are created by the set-aside. And another important kind of, feature of that to mention is, as a result of that restructuring of the EB-5 visa numbers, everything is current now. There is no cutoff date reported on the visa bulletin, which shows the date later than which an investor's visa case cannot continue. Because we had that pre-RIA, and we still do in the so-called unreserved category for Chinese and Indian investors. So this is a topic, to go deep into probably on another occasion, but this is a feature that is worth mentioning because everything is current, which means everybody who's eligible can file concurrently and file their adjustment of status. And once their case is approved, even if they're abroad, they can proceed to immigrant visa processing and interview. That will not always be the case because, to the point that you mentioned earlier, yes, we have these challenges and yes, it's resource intensive, but a lot of people are still very interested in immigrating to the U.S. through the EB-5 program. And there is a yet uncalculated number of people ahead of us. And once those numbers start to catch up with associated approvals on USCIS's side, we're going to start seeing that cutoff number be published in the visa bulletin. We don't know exactly when. There are some favorable prognostications out there, but that day will come.
Exactly. But I mean, that's why people should always, and this is something we mention every time, work with an immigration attorney and with an immigration professional. That's the reason why we have an expert like you talking about this.
Well, it's a great pleasure.
And I'm just going to close our conversation with the same cliche question that I always ask in the end. So what will be the key advice that you will give someone who's thinking about the EB-5 avenue?
Oh, wow. Well, you're going to laugh, but the first thing that came to my mind is make sure you have a competent, skilled, and caring attorney. It does not have to be us. Okay? But competent, skilled, caring attorney. This is a journey. I'm happy to say, being with Journey as the host of this podcast, it's an odyssey. And that is how I think of it. Maybe because I live in Ithaca, the home of Odysseus. But it is an odyssey, and it can be hard. It'll have these moments of joy and elation and victory, but it also has these moments of emotional toll being taken on the applicant, often family members, this uncertainty, and so you want people in your corner who you're just going to be glad are in the boat with you, in whatever role, piloting the seas ahead, or holding your hand, rooting for you. That's I think really, really important.
That's a great piece of advice. And is if I will ever have that amount to invest somewhere in the US, I will definitely come to you, Carolyn. You make me feel that I'm well taken care of, for sure.
Well,
Carolyn,
that's our goal.
Thank you so much for coming to our podcast today. Thank you for all the information that you gave us. Thank you to you guys listening from home, from wherever you are. Just don't forget to subscribe and keep watching the channel just to learn more about the best avenues and the best chances for you to immigrate to the US. And Carolyn, again, thank you so much for being with us, and I hope to talk to you again.
Marcos, it's a pleasure. Thank you for having me.
Cheers. Thanks.